Hey guys, we are back here for another video and want to jump into this situation. We're still talking married to medicine that that I want to talk about is we are still talking about this judgment, and I want to kind of work myself back because what originally happened is I received the information, and generally, when you get court stuff, you want to read the complaint, because if you don't read the complaint, you have no idea what's going on. So that is originally where I started off, like, hey, I got to read the judgment. But what I failed to do, guys, it is so many documents. When I tell you it is so many individual documents, there's a lot. Somebody was like, the judgment has been entered, because I was thinking that it was still ongoing, but apparently this month it was resolved and it was a judgment entered. Now I know some of y'all like, well, how much do they owe? Based on what I read, the judgment was entered. They're going back to court to kind of decide what that amount is going to be.
Please, I don't have any time for any gossip now. Eh? Yes.
So they will go back to court to actually decide the actual amount of the judgment, but it looks like it has been granted. I'm going to show you guys that. So originally I looked at the complaint and I was like, okay, it's taking a long time, but that's not unusual. This is Georgia. And it did take a long time. Remember, I said it was filed in 2023. Well, it was concluded in March. I want to say March 12th, so maybe a week or so ago. But what was not settled is they did not agree on the amount. Well, I shouldn't say the amount. They're going to come back to court to establish that. Also, they did have mediation in December. It failed. Now, somebody had to tell me that. Like I said, y'all, it is so many documents that I hadn't, got a chance to work my way down, because I mean, it's just a lot of documents. But what I want to do is, I be reading the comments sometimes and y'all be helping me. So let's get one thing out. Like, one thing we know to be certain. Now, the car that he gave Quad, that is not a Rolls-Royce Cullinan. That's not it. But you guys said one thing to me and I was like, oh, let me go back and look. The car that he was driving is in fact a Rolls-Royce Cullinan. Now, I don't know if this is the car that they're looking for, but it is in fact a Rolls-Royce Cullinan. So I wanted to point that out. Now, for some of you who may forgot, I want to get into what that vehicle looks like, because it was actually featured on the show. Again, I don't know if this is the car. I don't know if this is the actual one they're looking for, but baby, this is most definitely a Rolls-Royce Cullinan.
What do we have here?
Now, if you guys remember that particular episode, okay, and you guys had to remind me, because I thought that he had drove the one that he said, that he had given to her, but it is not the same car. That is in fact a Rolls-Royce Cullinan. I don't know if that's the one that they're looking for, but what a coincidence, right? I don't know, but what a coincidence. Something in the milk ain't right. But what I want to get into, what I would like to get into is the actual documents, because as I stated, to you guys before, when I originally started reading this, I didn't even realize that this case is over. There is one thing that is left to handle, and that is how much are they going to have to pay these people? Because the judge has ordered that, hey, this is done. Now, if you guys recall, when I originally read this, I had mentioned to you all that they asked for a jury trial. Well, they didn't have a jury trial. So from what I'm reading, it seemed like the judge was like, man, we're not going to waste nobody's time with no jury trial. This is a no-brainer, because the judge sided with the owners of the car. And I'm going to get into it. Now, if you guys recall, I'm glad I actually came back on and read the the complaint more in detail, because if you guys recall what I read, they said that they wanted 3 times. So we'll, come back on here and, talk about what the actual judgment is going to be, because if I'm correct, it's the 26th. If I'm correct, I think it's the 26th that they go back to court, which is next week, Wednesday. But let's kind of get into it here and kind of get into it. So if you guys can see, this is the luxury lease company, the same company that is suing these individuals. We got the same people. We got Carlton L. Curry, Carlton L. Curry II, his company Flipping with Carlton LLC, Janiqua Mason, Kirt Andrew King with Atlanta Exotic and Luxury Car Rentals LLC. Here we go. So this is the order granting summary judgment. So pretty much this is the judge's order. So this is a wrap. Look at here, y'all. 3/12. So this was concluded about a week ago? Yeah, a little over a week ago. So let's get into it. So it goes pretty much into the motion that was filed. It lists their name. It lists the car. It lists the business. I'm not going to read that because, we already know. Okay, so it also goes on to say that Miss Mason did not show up. It says defendant Mason failed to respond to the plaintiff's request for admissions, and same are deemed admitted. So what that means, the people that's suing you, reaching out to you, asking you some questions, you don't respond. So because you did not respond, you admitted. Because if you cannot respond, you guys, if you don't know, here you go. If somebody sue you and you don't show up, they won. So that's how it goes. This is what happened here. But how interesting is that? You rented a car. You're an innocent person, allegedly an innocent person. It don't look very innocent to me. You rent a car, okay? You don't show up to court. So I rent a car from Avis, a Hertz. I found out it's some shady business. I'm getting sued. I'm going to court, okay? So a person who wants to rent a Rolls Royce gets sloppy drunk and don't show up for court. Y'all, is given ghetto. That's what it's given. I'm sorry it is, because this don't make sense. You got Rolls Royce taste. You get sloppy drunk and then you don't show up for court. I don't know what else to say about this. Like, lady, this don't make sense. You are an innocent person that don't show up for court to tell the judge, like, hey, I just rented the car. I don't know. That seems very suspect. It seems suspect. I'm sorry. And apparently the judge felt a little suspect too, because this is his findings. And this is pretty much what the judge is laying out as the reason as to why he concluded that the judgment is going to go with the owner to these people, because this stuff don't make sense. So this lady did not show up. Because she did not show up, it's a wrap for her. It looks like King may have, submitted in his response that maybe he felt like he should be dismissed. The judge wasn't buying it. No, sir, you will be included in this as well. Now, findings of fact. Now, it goes on to say that the plaintiff is the title owner of the Rolls, okay, which was leased by Curry, using, him and his business name. Now, this is where the judge, I really like this part, because the judge is basically saying, this is what you signed, okay? So what the judge is saying, despite the fact that the lease documents clearly, specifically, and repeatedly prohibit the defendants from transferring any interest in this lease or this Rolls Royce, from selling or co-signing this car to anyone, including a dealership, an individual, assigning, swapping, transferring, leasing, subletting, lending, renting, sharing, advertising, offering, engage. None of the above activities can you do. It says this repeatedly. This is what the judge is saying, okay? And it also says that the lease rental agreement prohibits prohibits, guys, there is a GPS agreement, right? And it prohibits, you cannot disconnect it. What it says is the Curry and the defendants entered into an arrangement. I'm sorry, let me go back. I think I missed something. Okay, so back onto the GPS. It says it does say that the Curry defendants entered into an arrangement with AE through King to rent the rules to third parties on daily, weekly, or other basis, and Curry II delivered the rules and keys to same to the King defendants about a week prior to renting the rules to defendant Mason. So you rented a car, you knew that you was not supposed to be renting to other people, you did it anyway. That's what it says. Now, it says Mason obtained possession of the car from King on June 8th. Now, King is Quad's boyfriend, married to medicine. Okay. She obtained this vehicle from him on June 8th of 2023 because she rented it from AE. I'm just trying to figure out what is AE. That has to be one of their, okay, maybe it's Atlanta Exotic. Okay, this is King's business. Okay, she rented it from AE. Think they abbreviated it because these business names are really long. Okay, now it says on the morning of June 10th, 2023, defendant Mason made a police report with the South Fulton Police Department that she got sloppy drunk and lost the keys. Now this lady is unhinged. She don't show up for court. She rent Rolls Royce and get sloppy drunk and don't know where the keys at. This lady is unhinged. I mean, come on now. She thought she had the keys with her when she went to sleep. Upon waking the following morning, she discovered that the keys were missing. Okay. Now, the owner was not aware of the subleasing and the rental of the Rolls Royce to King. AE is Atlanta Exotic, whatever the name of his business is. Okay. They didn't know that, they were doing this, renting this car to Mason until Curry contacted the owner to report that he believed that the Rolls had been stolen. Remember I said that? Curry reported, it's been stolen. Now, the plaintiff never gave Curry, the defendants, or King, or anybody permission to rent this Rolls Royce to Mason or anybody else, nor did Luxury Lease give Curry the second individually, King defendants, or anybody. They didn't give you permission to be in possession of this car. Now, the Rolls Royce was never recovered. The defendants, listen to this, guys, they admit. So, what are we having a jury trial for? I thought people have a jury trial when you want them to prove something. What is there to prove here? They admitted it. This is what the judge is saying. The judge is saying that they admit to signing the lease documents for the lease of the Rolls, and they guaranteed and admit that they had failed to make payments on this lease. They admit that they violated the rental agreement and the provisions of the lease. And it hasn't been recovered. The car hasn't been recovered. All the defendants admit to having been in possession, dominion, y'all know what dominion means, or control of the Rolls to be subleased and subrented to Atlanta Exotic and Mason. So why does King have this car and renting it to somebody else? That don't make sense, does it? All right, y'all, let's keep going. I don't understand why they would need a jury trial for this. And that is probably why the judge ruled, you ain't finna waste the court's time. Let's get this on. Admissions, discovery responses, and deposition testimony. You testify, you get a court reporter to record it. Deposition testimony of the defendants established as a matter of undisputed fact. all the elements of the plaintiff's case. Why? Okay, y'all. Why would they have a jury trial? They admitted it. Generally, when you have a jury trial, it's because you said the person did something and they said, no, I did not. They admitted it. A jury trial for what? There is no jury trial. So originally, the person who owned this vehicle was like, look, let's get a jury trial. They admitted it. It's no jury trial. Hello. They admitted it. This is what the judges, his final, what do you want to call this? A final judgment. This is what he's saying. He's also saying the defendants are jointly and severally liable for all damages specified in the complaint for breach of the lease and against all defendants for conversion of the plaintiff's interest in the rules. Accordingly, the plaintiff is entitled to entry judgment, summary judgment in its favor on all claims, guilty on all charges. In its complaint, and it said denial of the King defendants, MSJ, MTD, and dismissal with prejudice of the King defendants counterclaim. So it looks like they try to sue him. I'm not going to look it up because it don't matter. Y'all lost, okay? Conclusions of law. Now, I'm not going to read all that fancy stuff. Absolutely not. But we're going to get to the part where the judge is pretty much saying, what are we doing here? You signed this. The lease says this. And guess what y'all did? Y'all signed it. So what are we doing here? Let's get into it. The lease states in paragraph 20, this vehicle cannot be leased or rented to others or advertised or offered for lease or rent to others. Paragraph 21, I understand that I have no right to transfer any interest in this lease or vehicle, and that I'm specifically prohibited from selling or co-signing the vehicle to anyone, including a dealership or individual, assigning, swapping, or transferring the lease, subletting, lending, sharing, renting the vehicle, or advertising or offering to engage in any of the aforementioned activities. They agreed that they wouldn't do it, but it gets even more crazy, okay? Paragraph 28, I agree to not relinquish possession of the vehicle to any person or entity for any reason without written permission. It simply says you can't do it. You need to ask us and we need to give you written permission. Paragraph 28, I agree not to relinquish possession of the vehicle to any person or entity for any reason without written permission. Did I just read that? But anyway, read it again. Okay, further, the notice of the rental prohibition signed with the lease, it states this: per the terms of this lease, you may not advertise, offer, rent this vehicle, lease this vehicle on behalf of a third party, sublease, release this vehicle to a third party, sell your interest in the lease, use this vehicle for hire car services or car or ride share services. Ooh, they sign this. But it gets even more deeper. If it is discovered that the vehicle has been used for any of these purposes, the vehicle will be subject to immediate repossession without notice. To redeem the vehicle, you would owe the full remaining contractual balance on the lease. So it means they can take it, and now you got to pay them anyways. which would be the sum of your remaining lease payments plus the residual value and any repossession costs. We acknowledge that we have read and reviewed the above notice and agreed that the vehicle will not be used for the above prohibited purposes. They agreed to this. So again, a jury trial for what? Okay. Now, in paragraph 16 of the lease, the judge is saying this is what it provides. I agree to be responsible for and bear the risk of damage, destruction, confiscation, theft, loss, conversion, or abandonment of the vehicle during the lease term and until I return the vehicle to you, and to immediately notify you that insurance company and any proper governmental authority in the event or threat of any such happening. If the vehicle is damaged and in your sole opinion, it is a total loss or the same, is stolen and or recovered or is subject to undue peril, or if any other occurrence and condition included above happens, you reserve the right to terminate the lease as of the end of the month in which such event occurs or such later date as you determine. You will not provide a substitute vehicle. So they can take the car, they're not giving you another one. This is what they sign. Upon such termination of lease, any termination liability payable to you on demand will be calculated and determined under section 14B, paragraph 2, whatever that means. I don't know what that means. Or your actual damages under section 28. I think this is part of the agreement. I'm not pulling it up. We're just reading what the judge ruled on. Whichever you may elect. While my termination liability shall be reduced by any insurance proceeds you receive, I also acknowledge my liability as stated in section 9 for any difference between my termination liability and the amount of such insurance proceeds. So basically, guys, they're saying that if the car even was stolen, they would have to pay or their insurance would have to pay. So it's like they signed this already. So the judge is just reciting what they already said, what they agreed to. Like the judge, I mean, if you agree to something, what is the judge going to do? Like you agreed that if this car was stolen, you would be responsible. You agreed to this. So why would the judge say, nah, they don't need to be responsible because the car was actually stolen? But you signed it saying that if it was stolen, you would be responsible. I mean, they don't need a jury trial for this. I mean, they agreed to the terms and they violated it. There is no dispute that the defendant signed the lease, guarantee, the GPS agreement, and rental prohibition. So basically, the judge is saying, what's the dispute? You signed the lease, you signed the GPS, stipulation that said you would keep the GPS in the car. You said that you wouldn't rent it to anybody else. There is no dispute here. There is no dispute that the defendants failed to timely make payments on the lease and they failed to pay the amount of money that they owed on the lease. There's no dispute. That's what I'm trying to tell y'all. A jury trial is for when there is a dispute. What are we having a jury trial for? They didn't dispute it. Finally, there is no dispute that the defendants breached the lease documents by providing the rules to King defendants to rent out to third parties and allow the King defendants to rent it to Mason, and that the rules has not been recovered. There is no dispute. Now, I'm not a lawyer, but this to me is basic common sense. What are we having a jury trial for? There is no dispute. Thus, as a matter of law, in fact, the defendants are liable to the plaintiff for all remaining lease payments owed under the lease and other charges under the terms of this lease. Mic drop. I mean, are y'all following me here? Because, I mean, again, a jury trial is when we don't agree. You don't have a jury trial when you agree that these things happen. So I can understand why the judge like, hold on, wait a minute, wait a minute, wait a minute. So this is what it says. The plaintiff is also entitled to summary judgment against all defendants for conversion of the plaintiff's interest in the rules because the defendants admit they violated the rental prohibition and similar terms of the lease, and the King defendants and Mason admit to having possession of the rules without the owner's permission. Y'all, this is crazy. Okay. Let's see if this is something I want to read. Let's read this. Conversion is any distinct act of dominion wrongfully asserted over one's property in denial of his right or inconsistent with it. Now they list a case. I'm not a lawyer, so hey. Conversion constitutes an unauthorized assumption and exercise of the right of ownership over personal property belonging to another in hostility to his rights, an act of dominion over the personal property of another inconsistent with his rights, or an unauthorized appropriation. Now they list a court case, okay? Any distinct act of dominion wrongfully asserted over one's property in denial of his right or inconsistent with it is conversion. I know what conversion is. Hey. Now the action of trover being founded on a conjunct right of property and possession, any act of the defendant which mitigates or is inconsistent with such right amounts in law to a conversion. Okay, so it looks like he's, let's see, do I want to read the rest of this? Okay, what does that mean? Okay, now it says, so the judge is going into this actual other part, and is saying how they establish this. It says to establish a prima facie, I don't know if I'm pronouncing that right, case for conversion, the complaining party must show title to the property or the right of possession, actual possession in the other party, demand for the return of the property, and refusal by the other party to return the property. Hello, I feel like they established this. So what they're saying is, in order for this owner to establish this one case, they have to establish they have the title. They established that they provided the title. They have to establish that the other person is in actual possession. They established that. They also established that they tried to get the property back. They also have to establish that it wasn't returned. So it was established. The undisputed facts here establish each of these elements. Y'all, I knew I should have been a lawyer. It is undisputed that the plaintiff is the owner of the rules. They have the verified complaint from the actual owner who has, got this company to do all the work for them. Obviously, this person lives in another state. It goes on to say the Curry defendants' amended answer, although the defendants had a right to possession of the rules by virtue of the lease, such possession was only permitted in compliance with the terms of the lease. Remember, it was rented to one person. It was not supposed to be rented to other people. We're not even getting into the GPS and all of that. So it says, which they admit was violated by a law allowing Atlanta Exotic to broker and rent the rules to Mason. And once the defendants breached the lease, they lost the right of possession to the Rolls Royce. Right, because it said in the lease that if you do these things, it's a wrap. Curry II admits delivering the keys to the Royce to Atlanta. Ecstatic and King defendants admit being into possession of the Royce thereafter until it was rented to Mason. So again, we having a jury trial for what now? There's no jury trial. Mason admits being in possession of the Royce from June 8th, 2023 to June 10th, 2023. That is, of course, y'all know what I'm about to say, until she got sloppy drunk. That is until she got sloppy drunk, because we know once she got sloppy drunk and left, she left a Rolls Royce unlocked with the keys in it, y'all. She left a Rolls Royce unlocked with the keys in it. And some of y'all driving a Honda Accord and your door is locked. This lady, sloppy drunk lady, left a Rolls Royce unlocked with the keys in it in a parking lot at her residence until she discovered the next morning on June 20th, 2024, that somebody had taken it. Well, ma'am, you practically gave it away. I mean, come on now. You that don't even make sense. Now, it seems like in some part of this, I don't know how they figured out that she left it running with the keys in it. Now, okay, y'all. Okay. You remember that you were sloppy drunk, and you remember that you left the keys in the car running. Now, I done told y'all, like, I done had my days, when I was 18, 19, and 20, honey, it seemed like I was never at home because I was always in somebody's club. Reason why I don't really like it now, because I was clubbing every single day. But one thing I don't remember is being sloppy drunk. Now, people would tell me I never could say I was sloppy drunk. Now, I knew things happened because people would tell me, and I will remember certain things. But how do you remember everything that happened when you say you were sloppy drunk? But anyways, I'm just saying. So in the complaint, the owner demanded return of the car from the defendants, and no such demand was necessary because at the time of filing the suit, making a demand for return of the Rolls Royce was futile. Oh, I gotta look that word up. I just be learning stuff. I don't know what that means. Well, I'm about to look it up. Let's look that up. Okay, futile. What that mean? Let me see if I can. I wanted to pronounce it too. Y'all know how y'all can get
Futile.
feudal. Okay. Feudal it is. So what else are they talking about? Okay, it says to prove conversion, it does not require a showing of a demand refusal. It only requires that the defendant who comes into possession of the property unlawful for any period of time. So they prove that. Hello. Okay. It says to make out a prima facie case in an action for damages for conversion of personal property, the plaintiff must show, it says must show. That's a misspell. Title to the property, possession by the defendant, demand for possession and refusal to surrender the property, or an actual conversion prior to filing suit. It lists the case. Moreover, whether or not the defendants, Curry, two, individually King, the other defendants, and Mason, knew that the Royce was owned by luxury lease and the lease prohibited it from being leased, subleased, rented, subrented to any third party is immaterial to a claim for conversion. So the judge, like, what are we doing? You knew this already. How did the judge know? Because there is a lot of answers. So maybe somewhere they admitted it. I don't know, but there is definitely not a need for a jury trial, because what we gonna learn here? Y'all admitted everything. Hello. It is immaterial that such dominion was exercised in good faith for whomever meddles with another's properties, whether as a principal or agent, does so at his peril, and it makes no difference that in doing so he acts in good faith. It is thus established that the fact that possession of stolen property, I've been trying to tell y'all forever that they're saying that they stole it. Hello, stolen property, stuff that you did not pay for. Unlawful as against the true owner may have been acquired in good faith, will not prevent such possession from operating as a conversion against the true owner. Whew, this is too much. So this is too much. Now, it says that the defendant is taking possession of the property without the true owner's consent. They're guilty of conversion as to the true owner, although the defendant, being ignorant of the true owner's title, may have acted in perfect good faith, and the defendant could be sued in trover, I hope I'm saying that right, for the property even after his delivery of it to his principal. It goes on to say, moreover, conversion and theft are two different things. Okay. Conversion is a civil claim and theft is a criminal claim. So in this particular case, okay, conversion is it's different than that. He said it. So we're just gonna leave it at that. A party may be guilty of conversion without being the party who stole the vehicle. Okay. He lists a case. Thus, regardless of whether any of the defendants participated in what appears to be likely the theft, y'all heard that, of the royals by some person, all the defendants did covert plaintiff's interest in the rules by wrongfully possessing and asserting dominion over somebody else's property. That's what it says. Who in denial or its rights thereto or inconsistent with it. The plaintiff was damaged by the defendant's conversion of the rules because as a result of the same, it is lost or stolen and has not been recovered. The undisputed evidence showed that the value of the Rolls Royce is at least $170,000. Isn't that crazy how they, that's why cars be something. They were, I think they said it was like 335, but the real value is 170. This is what it says. And the plaintiff is entitled to recover punitive damages for or from the defendants. Conversion of the plaintiff's interest in the rules, as well as its attorney fees and litigation costs incurred in pursuing this action. And of course, it gives us a good old court case to look up. Conversion is an intentional tort and will support an award of attorney fees and an award of punitive damages, y'all. So they won punitive damages. So we're going to have to come back and see what the number is going to be. The clear and convincing evidence in this case shows that the defendant's actions in violating the rental provisions of the lease. That's it. Allowing Atlanta Exotic to what is it? Ecstatic. Yeah, ecstatic. To broker and rent the rules to Mason and Mason, failure to protect the rules from theft or loss, as well as failing to cooperate with the insurance claim. Oh, there we go. So they, and you remember I said, y'all, I said in the complaint, it's making it seem like they're not cooperating, which is kind of crazy because if somebody stole a car, tell these people what they need to know so that they can move on. And this was the problem. It's like this implied guilt here because why wouldn't you want to talk to the insurance company? You know why? Because the insurance companies, they investigate, and the insurance company will put you in jail. So they didn't cooperate with the insurance company. They probably couldn't get any information. I'm surprised the insurance company didn't come after them because insurance companies will come after you now. I do know that they will do that. So they didn't cooperate with the insurance claim on same show willful misconduct, malice, fraud, wantonness, oppression, or the entire want to care. Oh, I got to read that again. It says that their failure to cooperate with the insurance company, the claim on same, it shows the willful misconduct, the malice, fraud, wantonness, oppression, or that they just didn't give up. That's what it says, which raises the presumption of conscious indifference to consequences. So it's like, you remember when I read this before and I said that, wow, you do business with somebody, you obviously think, they're honest enough because you did business with them. How did they go from that to this? Because you remember when I was reading it, I said, they're making it seem like they committed a crime. This is why. This is why. Now it all makes sense, right? Boy, that was a heck of a statement. I got to read that again. It says, their failure to cooperate with the insurance company in the claim show their willful misconduct, their malice, fraud, wantonness, oppression, or that they just didn't give a F. That's what it says. Moreover, the defendants, King and Curry, are personally liable in tort for the fact of conversion. Personal liability extends to individuals who participate in or direct the conversion, even if they are acting on behalf of a corporation or limited liability company. So sometimes people will, get things in their business name and, they, kind of feel like, if it's in my business name, if it go bad, you can't do nothing to me. This ain't the case here. This is not the case here. Let me read it again. Personal liability. Although they put it in their business name, you are personally liable. It extends to individuals who participate in or direct the conversion, even if they are acting on the behalf of a company or corporation. They don't care. We putting this on your name too. Who? An LLC member may be held individually liable if they personally participate or cooperate in a tort committed by an LLC or direct it to be done. Further, it is irrelevant that defendants no longer have possession of the rules. They were the link in the chain that led to the rules being lost or stolen. Curry, the defendants, and King, defendants, were the Oh, I got to look that word up. I don't know. Oh my gosh. What is that? What is it? Arbitrators of whom the rules was rented to. And it was rented to Mason without the authorization of luxury lease. Now, he's listing like other cases, okay? Each party found guilty of conversion is liable for the full amount. So it simply means all of us is liable if you pay is paid, but we're equally liable. So there is no way to say, okay, it's $1 million. We're going to split it between 3 people and then it's 3 something apiece. Nah, that's not what that means. It means that the $1 million going to be on everybody. And when it's paid, it is paid. That's what that means. Okay, it's arbiter. So I was right. Okay. Writ of possession. Although the rules Royce has not been recovered, same does not negate the plaintiff is entitled to a writ of possession. In the event that the rules is at some point located by law enforcement or otherwise. List a case number. Plaintiff made a significant showing that it is entitled to a writ of possession in its verified complaint. It says the plaintiff attached hereto a true copy of the Rolls Royce title showing plaintiff's ownership. And I think I showed that in my last video. It says further defendants flipping Curry Sr., Curry II, and Mason admit that plaintiff is entitled to writ of possession of the Rolls Royce. So isn't that crazy how they didn't fight any of this? I mean, listen, I didn't steal a car. I just rented it. So isn't it just so easy how they just didn't seem to care? So it seems like, and I'm just saying, I'm just thinking, the paperwork don't say this. So it's easier just to not say nothing because when you start talking, you dig a hole for yourself. This is given something that happened that wasn't supposed to. This is not given that this car was stolen. It's really given that there were a few individuals involved in this car just vanishing. Somebody saying you knew you were sloppy drunk. You left the car in the keys running with the doors unlocked. Girl, get that up out of here. That don't even make sense. Okay. That makes no sense. According, it is hereby ordered and adjudged that summary judgment is granted in the favor of the plaintiff and against defendants Curry Sr., Curry II, his business flipping King, Kirt King, Atlanta Ecstatic, and Mason jointly and severally as follows. Okay, on count 1, as to the defendants jointly and severally for an amount to be determined at a hearing on damages. Remember, I said they're going to have another hearing to discuss what they got to pay. On count 2, as to all defendants jointly and severally, y'all all got to pay. Okay, a writ of possession as to the rules is hereby entered and the plaintiff is entitled to possession of the rules. That's if it's found. Defendants or any other person in possession of these rules be and hereby are restrained and or enjoined from transferring, removing, or conveying this rules or its proceeds, and that any proceeds from the sale of the rules be turned over to the plaintiff. The sheriff or marshal of this state or any other state is authorized and ordered to recover possession of the rules and relinquish same to plaintiff if the rules is found. The sheriff or the marshal of this state or any other state may use any and all force necessary or appropriate to repossess the rules and to gain entry to any premises where the rules is located, and to take possession, therefore, including but not limited to removing any locks or otherwise gaining access to any secure premises where this car is located. On count 3, as to the defendants jointly and severally, judgment against defendants for conversion and or damage and complete loss of the rules for an amount to be determined at a later date. So they are coming back to court. Remember, they won. It is further ordered and adjudicated that King defendants MSJ MTD is hereby denied with prejudice. Okay, it is just so King submitted a counterclaim, y'all. It says it is hereby ordered and a judge that the King defendant's counterclaim is dismissed with prejudice. Further order that the clerk issue a writ of whatever that word is. So there y'all go. It's over. So again, I just wanted to come on here because when I did the video, I actually did the complaint. And somebody was like, girl, it's a wrap. Because when I was doing the video, I said, you know, this is Georgia. It takes a minute. This is Georgia, and it does take a minute. But baby, this is over. They have been found in default. So what is going to happen? Let me see if I got my Odyssey open, because it will log you out. So what has happened is they got to come back to court, and they're going to determine what, you know, what's going to be the judgment amount is pretty much what's going to happen. So they have not determined what the judgment amount is going to be. Okay. So that is going to come up at a later date. I'm going to see if I can sign into Odyssey, because I believe that the court hearing is next week. As a matter of fact, I don't need to sign in. I really don't. I already know the court hearing is going to be next week on the 25th. I already know this, so I don't need to show you guys anything else. Again, I just wanted to jump on here and let y'all know. So let's just recap and clarify. The judgment was entered. So they sued King and these other individuals. This complaint was filed in 2023. Now I know, some people are like, well, what was going on? Court takes a long time. They went to mediation in December of 2024. Nothing was resolved. Now, when the owner of the vehicle originally filed a complaint, they said, look, we're going to have to go to a jury trial. There is no jury trial. As you guys, were listening, the judge is like, they admitted this, they admitted that. What are we having a jury trial for? There is nothing for the jury to decide. These people have already admitted guilt. So with that said, it's a wrap. And I will, like I said, find out what's going on with the judgment. Also, the attorney wants to come on Sunday. So I'm going to bring him on Sunday. And, of course, he can, say whatever, because we're just reading from the documents. I don't know anything other than what I read, but I'm going to be honest. The evidence was overly convincing. The fact that they did not have a jury trial and the fact that they admitted it. So I don't know what else needs to be